we have Articles 1 through 4 beginning
Okay.
ready that we can go ahead and present. And then if you have summary for us, and then we'll have another little batch. How does that
Okay,
sound?
and then we have dinner at some point, is that right?
And then dinner, yeah.
So if we go back and forth here, get these done, and then you guys can visit over dinner?
Sounds great.
Okay.
Okay, so we're gonna send around Article 1, recognition. And I'm gonna have, Amber is gonna speak to this one, introduce it.
Thank you.
Oh, oh, I'm just gonna question.
Wait for Andy and Susie. All right, do we have everybody? Are you all ready? Okay. I'm going to present Article 1. This is our opening proposal from GAACE. I pulled my microphone louder, so I just want to recognize if there's folks that are hard of hearing in the room, I want to make sure everybody can hear the presentation. All right, so for Article 1, I'm going to kind of give you the overview. I'm not going to go through every single line by line, but generally speaking, our intent is to make sure for the recognition of who would be included in the GAACE bargaining unit that we're not going to end up losing people. That's our kind of biggest concern. We don't want people to be removed from the bargaining unit. And there's some lack of clarity right now with substitutes versus temp employees. It's unclear if we have people who are being classified as substitutes. So we struck out that section and we've really clumped them all together just as classified employees working less than 60 days. So whatever title you might give somebody, if they meet the definition of being a classified employee who works less than 60 days, then that's how they would, that would be, they're not in the bargaining unit. But once they're past 60 days, that's when they're in the bargaining unit. So that's our intent. That's what we're trying to do by cleaning this up. And then down in section 1.2, we are trying to make sure that folks get health insurance after they're here 61 days instead of 120. We believe 120 days is a really long time to go without health insurance. The health impacts on people who already have such low incomes could be really devastating to them and their families. And so we believe that the health insurance should start at 61 days. We'll also be modifying our health insurance article that talks about eligibility, but it is mentioned here in the recognition clause as well. So we want to make sure to keep it consistent throughout the CBA. And then I think the seniority we want to handle in the seniority article. But it is also mentioned that the seniority would start after the 61 days. I think that is, and then also it has the reference to seniority for all regular employees. And again, if you have some other title you're giving people of some sort of substitute, some sort of temporary interim position, whatever it might be, we want their seniority to start. So we've struck out regular and said just for all employees that seniority could start accruing. Questions on Article 1, just for clarifying to make sure you understand what we're proposing? Yeah.
We passed this article on the 5th, and I don't
Yes.
see
So-
any strikeout or.
Yes, so this does represent our opening proposal. We did look at what you had sent us, and we're going to continue to look at it, but at this time, we didn't incorporate those in.
Going back to 1.1, and I think you said, Amber, you were worried or didn't want anyone to get removed from the unit with that change. Do you believe, based on that change, there would be any positions currently not in the unit that would come into the unit?
Possibly. So the district student employees right now is listed as being excluded. And we're just not quite sure who you might end up thinking is a district student employee that might really be a classified employee who should be in this bargaining unit. And so we struck that out. We didn't think that that's an important distinction. If somebody's doing classified work in this district, they should be in the bargaining unit once they're past the 60 days. So we have a lot of people who do different student status. And we especially appreciate when we have students who our members have cultivated, mentored, taught, helped, assisted, they were aides for them and seen them grow up, and then they end up working for the district, right? And so there's this in-between period where sometimes maybe they're just finishing or they're in some of our special programs we have, and then they start working for the district. If they're doing classified work, they're getting paid in this district, then we think they should be in the bargaining unit once they're past those 60 days.
Thanks.
Yeah. Or if they're in a position that is going to last more than 60 days. Yeah.
Okay. Thank you.
And so then, if there's no further questions, we have Article 2. This is district rights.
Scratch that one too.
It's okay.
Okay.
Oh, no. That's Chris. Yeah.
And Brad, school board member, went to Sunrise to read.
You need extra copies.
Make sure he has it.
one of
Joanne,
each.
can you give 2 copies of that? Two more.
Article
One of
1
each
and
article.
Article 2.
That's
Right
one.
there.
We have ones for Brad there.
Never mind.
Nice.
Yeah.
Thank you.
Okay. So when we looked at this article, basically the purpose of what we've done here is really just kind of a little bit of cleaning up and making the contract a little more accessible, easy to read. Basically, most of the things that were outlined here is covered by state law. So we don't feel like there's a reason to keep going with that. The second part was the drug testing for bus drivers. We moved that to into Article 17. We felt like that was again, a cleanup, that wasn't the right spot for that.
Just one more piece. So in 2.2, it says, without limitation, but by way of illustration, the exclusive prerogatives, functions, and rights include, right? And so that exclusive prerogative makes it sound like these things management gets to just do completely, at their discretion. But many of these things, there are stipulations in the CBA, right? So it isn't the exclusive prerogative. The CBA does limit a lot of these. So in some ways, this could be confusing to a manager who might read it and think, oh, I can do anything on this particular item because it's listed here as an exclusive prerogative, even though it's not, because it contradicts the other articles in the CBA. So that was another reason this is cleanup, to make it consistent with the rest of the CBA.
And furthermore, hoping that, if there is a conflict to one of these items, it can better be served by using a grievance procedure rather than a lawsuit procedure, that works best for both. Oh, wrong one. Oh, the wrong one. Sorry. Sorry, I got ahead of myself. Okay.
So where did you're moving to Article 17, the drug testing for bus drivers, and that, does it appear there in the same language, or is that going to be modified, or?
I think we are working on a modification.
Okay.
When we present Article 17, you'll see it.
On 2.2, I understand the explanation that it may not be necessary to list all these things because they're generally covered in state law. Do you guys intend a substantive change here other than a cleanup? Like, are there any of those listed things that you believe would no longer be the district's within management rights as modified or controlled by the CBA?
Yeah, I think it would provide clarity to both sides, because I think there might be some where management believes that they do have the exclusive prerogative, and we do not believe they do. So I believe it provides clarity that they do not have the exclusive prerogative to do just about anything on some of these, like work days and hours of work. We have an entire article on that.
Sure.
So you could have a manager read this and think they could change somebody's hours of work however they want.
Yeah, I understand and agree
Yeah.
with you that all of these rights are subject to the CBA if there is CBA language on them. Agreeing. I guess I'm just trying to understand your proposal. So, for example, B is to determine and to follow district's financial, budgetary, and accounting procedures. Just as an example, are you proposing that that's no longer a management right, or that it's not necessary to state it there?
I would say that generally, the law is that it's the district's prerogative to figure out the district's financial, budgetary, accounting procedures, except where the CBA limits it. So we have payroll language about deductions from paychecks, and that does limit the accounting procedures in some ways. The payroll department does have to follow whatever might be in the CBA that impacts their work.
Okay, thank you.
Are there any further questions on Article 2? Okay. And then Article 3, non-discrimination. Bring that around.
Thank you.
Thanks.
Only took me a couple times. Thank you, chickadee. I'll take this for you. Thank you.
All right, and again, our purpose with this language is just, I don't think it's been changed for quite a while, so we have a lot of new education around discrimination and what we need to consider when we think about our people. And also this language we have taken directly from Lebanon, what they just bargained into theirs. And we believe it really covers what we need to have here to incorporate in our district.
Yeah. I think I'll point out several important pieces. One is that whether this is listed here or not, we all know that all employees in the country, and then for the parts that are specific to Oregon, everybody in Oregon can file a lawsuit over these things. But we believe it's in both parties' interests to not necessarily have more lawsuits. Our goal is to resolve things at the earliest, quickest step. And so by listing these out, our hope is that folks might seek a grievance instead of a lawsuit, if that's appropriate for that person, right? And so by having it here, that person could then think, okay, I'll try a union grievance, which, you know, in my experience, helping people who've been discriminated against, people who've been sexually harassed, they often don't want to have to go and live through a long court case. It's traumatic. It's the experience itself is pretty horrible. What they most often want is just for the discrimination or the sexual harassment to cease. And a grievance can do that. A grievance can help make their workplace be free of these things. It doesn't, allow for any kind of pain and suffering, damages. You know, there's no financial stuff. It's just to get the discrimination to stop. And so we would hope that our folks could see that they could file a grievance over those things. Second, I'll say listing it out does help with education for people to know. So that's why we wanted to share today here at the table that there is this list of protected statuses, that people deserve to have a workplace that's free of those types of discriminations. And specifically, Oregon has expanded the law to make sure people know that the type of hair that you have, hair texture, hair type, protected hairstyles are all protected under the law. And so if you're discriminated against because of the type of hairstyle you have, that like we have a right to do something about that. Also, the definition of sexual orientation, having that listed out and what it is from the law. We think all of that is very educational. And so that's why we like to have it listed out. And again, Lebanon just agreed to this language in full. This is copy paste from their CBA that is now ratified in Lebanon, so.
You have citations, sorry, can you guys hear me? Do you have citations for C? I see that you've cited 659A in B.
Yeah, I can get the citation for you.
Well, and then just a point, so in Article 2, we're like going to clean up everything because it exists in law, and yet here we're adding things because they exist in law.
Well,
And so we know that we have a duty in all of these areas that someone could file a complaint, KL complaint, that we have an officer that would be in charge of an investigation immediately, that I think is going to lead to a quick resolution, even compared to a grievance. So just a question theoretically about what do we keep in and what do we find efficiencies for?
Yeah, and I think that this one really, because there's not going to be any conflict in the rest of the CBA about this issue, right? This is, and definitely, like Amber said, education. A lot of this is new law that's passed quite recently, and that we want to make sure that everyone is aware of it. Where as far as when we had these struck out by items, it was because it could be, rather than educational, it could be more confusing and conflicting. So just for clarity's sake, we felt that one was served, that's how the best served in clarity.
We do not dispute that there's some old language.
Yes.
Thank you.
Thank you. Does anyone else have a question on Article 3? Okay. And then we have Article 4, contracting out.
It's handing out. Liz can do it. Melissa can do it. Okay. I do not intend to reciprocate.
Last time,
Last time I just eventually gave up.
yeah, same, but just, yep.
Okay.
All right, Amber's going to speak to this one.
Yeah, so this is Article 4, contracting out. Our intent with this article is first, in the first section, to try to make sure we can get good information about when the district would like to do contracting out. So we've listed out the specific information that we'd like to be provided to us if you're looking at contracting out, right? So the job title, job description, being able to compare to like other similar positions. I think all of those seem like they'd be very helpful for the association to assess contracting out. Sometimes we hear about contracting out and it makes people get nervous, like, are jobs being given away? What's going on? And once we get the full details, sometimes the case is like, you know, our own members are like, oh, good, I'm glad they're getting us that help temporarily with that contractor. Great. But we have to see all this information to be able to assess that and get to a spot where people then don't have that fear, right? So we think 4.1 will help with providing all of that specific information. And then in the next section, we have listed out that we would like to have the 90 days before you'd go to mediation. Under PECBA, if you do a demand to bargain, typically you have 90 days. PECBA doesn't require mediation over this, but we think mediation has always served us well for both sides. So we're okay with continuing to have the specific requirement that there would be mediation. But the rest of it, we would really like it to be more what it is for everybody else when you issue a notice that's a change to mandatory subjects of bargaining, that you have that 90-day window. And at the end of it, the employer can choose to implement, but also the union can choose to strike. So that is what exists for everybody else. And so we don't think that having an exception here just for this one group of workers to not be allowed to do that like everybody else has makes much sense. So we've struck out the section about strikes being null and void at the end of it. But we are okay again with going to mediation at 90 days. And then we've extended the whole process to the 135 days, which allows for that beginning window with the mediation. So it is a little bit longer than the normal process for everybody else, but this was going to be longer the way it was already written. So, I have to double check the math, but I believe us allowing for the mediation and then being able to then implement or strike, we felt like 135 days made sense. Questions on this?
Yeah, I have a couple. So in general, this language I always understood to be for like the long-term replacement of a given section of the district. Is that what you understand it to be? Because I thought I heard in your answer that, or your explanation, that like at times we would contract and you guys would look and say, what other conditions would there be other than if we were looking to, just move out the whole?
So not all contracting are the members of GAACE going to be against, right? So an example would be if the ESD has a variety of people that if we have a position that just keeps not being filled for a really long time, we might bring somebody in from the ESD, maybe very temporarily, which provides a huge relief to our own members who are struggling without that spot being filled. We might want to bargain about it because you might need to create some incentives to try to fill that hard to fill position, or maybe there's some other problem that needs to get solved so that people actually want to take those jobs. So we may still want to bargain about it, but like we'd want all the information to be able to review it and get a sense of like, is this something that really should be in our bargaining unit and you shouldn't be contracting out? Or is it something that it might benefit our own members to have that kind of temporary help?
Okay. Thank you.
Mm-hmm.
Are there any other questions on Article 4?
Thank you.
Okay. So I'll hand it over to you, Mr. Gardner.
Okay, so we're
That's
gonna,
our turn now?
we're gonna start
Susie will do it.
with,
Yeah.
See what I did?
We do have another batch, but we would take turns.
we're gonna start with Article 6. And as agreed now in our ground rules, when you get them, they'll be yellow.
Perfect.
And I'll wait till everybody gets it.
Can I have a highlighter? One of those, maybe it's circulated. I don't know where.
So, everybody have it? Article 6, working conditions. Gonna be honest that we really wanted to get in the inclement weather emergency response, because that's something that's been a huge issue at AIM back and forth, and so we want to get that in. And then we just fixed little things in the rest of the parts, like the 4-day work week. We just thought that some of it didn't make a lot of sense, and so we just added things like prior to final decision of the supervisor, you know, those kinds of things. Overtime compensation, when mutually agreed upon by the employee and their supervisor. It just, was just little things to help make it, easier to understand, but the main thing is, inclement weather emergency response that we, struck out and changed the whole thing. And Dave spent a lot of time working on this, and so I'm gonna let Dave, tell you, walk you through it, and then if you have any questions. Then we went procedures for coverage, 6.1917, we just cleaned up, little things that were in, the article. 6.21 hasn't been happening at all. I think it was a long time ago that it was written, and so we wrote, elementary schools may be provided additional clerical hours for purposes of school startup upon request. Because there was the size of the school, how many hours, and it hasn't been used for a long time.
Are you saying, sorry, can I ask a clarifying question? Are you saying that no schools are bringing staff in sooner for a couple extra days?
And using this language on the, there was a lot of language about how much time, how big the school was, how many hours they would get for school. So we just said upon request, because it hasn't been used in the manner that it was for a long time. So, I'm gonna let Dave, go over, inclement weather, because that's what we really fixed in this article on, 6.10. And I know that he had lots of conversations with you guys and his team, so.
I'll give a little summary of it because Joanne and Liz have the history. Yeah, we met several times over the last year or so working on this language, so they have some of the background on it. But really, the premise of this is to provide ample notice to employees to keep people off the roads in the morning when they don't need to. So the goal is to provide good notice to people. We have specific timelines to make decisions for delays or closures based really on when our buses can run. So we want to communicate those timelines because I think that helps inform people about when the notices will come out. It's clear, right? If we're going to cancel school, if we do a delay and we're going to cancel, you're going to get the notice by 7:30. There's other things in here about noticing people the day before, like our bus drivers by 3:30, we can say we have a weather watch on hold, so we alert them the night before that we're watching the weather and there may be an inclement weather, because we have a lot of bus drivers that will come in early and hang out in the room there, and we don't want them on the roads, right? We also have employees that start work at 4:30 in the morning. So by giving a notice the night before, it again puts them on notice to be watching for alerts and to hold at home types of things. So this was really about safety. from that aspect. And then the other thing that we want to do is make sure we have enough help to get our buildings prepared in the morning when we can. Some custodians can come in, or are willing to come in early and to help us out. That really helps the facility staff. So there's a section in there about if you're able to come in and willing to help us out, we just want to know that. And so there's a section in there about that. For example, Joanne lives in an area that has inclement weather and she can't get in. We have other custodians that can, maybe. So we sent more facility staff to Oak Grove to help that school out than we did to other schools. So it's just being really planful and thoughtful about that. And I do want to point out, I believe numbers 7, 8, and 9 is current language. And that's my error, that formatting shouldn't be underlined and bolded. And that's my fault. But I believe that's current language.
7, 8.
I believe 7, 8, and 9 is
And 9,
current
okay.
language, and that's my fault. I sent that to Susie. But when we were working on it, when Joanne and Liz and I were working on it, we wanted to make sure it was clear that we were including all the article, so we didn't miss anything.
Okay, questions?
I have one. Would inclement, like your intent on inclement weather, would it apply to closures with severe smoke due to wildfires? Or are you thinking it's just like ice and snow? Or do you need to think on that? It's okay.
I think it would apply to all closures, wouldn't it?
That's a good question, but we'll go
Good
back and kind
question,
of look at it
yeah.
and see if that would apply in that situation. Thank you.
I have a clarifying question too. I was thinking the opposite. What about heat? Because we've had, last June, we had several days that were well too hot to have school or recesses. So would that be covered also under inclement weather?
I believe we would follow our heat awareness plan on that.
No, but if you have a school closure due to the
Oh.
heat, then would you be using these staff in this manner to come and still come to the buildings?
Yeah, I'm not sure.
I don't think
about
we'd
it.
have the same need to like salt the driveways or anything
No,
like that.
no, I don't think-
Emergency crew might be a little different. We'd have to think about that.
If it's heat related, we probably wouldn't want them to be there anyway. Right? So I'm not sure.
Okay.
Yeah. Thank you.
Liz has a question.
I just really want to take a moment to talk about all the great work that has happened. Even though we haven't been able to come to an agreement on a lot of these things, there has been great work done to move faster, smarter, better, sooner. And I think this year we've had a lot less complaints from the association to the association regarding the safety around inclement weather. And I just really want to, Jamin and his team did a lot of great work on this as well. A lot of input from a lot of folks, especially our 12-month folks, that Dave and his crew worked really hard to listen, absorb, and really focus on safety when it came to these things. And so I just really want to say, like, yes, group effort for sure, but it is up to you to implement it, and you guys have been doing a wonderful job.
Well, I think the biggest help has been the custodial support the night before. So being planful the night before, I think having custodians that are able to adjust their schedules and recognize this is important, spread down the de-icer the night before, that's been the biggest help. And so getting that buy-in to get our schools safe in the morning has probably been the best thing.
And the safety first. You've always put that first on this. That was important.
Our dinner is ready and it's warm, so I think if we went through these three, it might be cold. Would you like to take a break and get dinner?
Sounds good.
Yeah, everything's in the staff room out there. Help yourself. There's drinks up there as well. There's fresh potted coffee, if you didn't see it over here. There's this water, or if you have a water bottle, again, the filling station is down that way.
And once your team has all gotten all the food that you need, can you let us know? Because we might, if there's leftover, we might offer it up.
Okay.
So can you just tell us once
Do
you
you
guys
want us
have all
to get
gotten?
first shot at it?
No, they're going first.
Okay.
Team's going first.
Yeah,
then
you
we'll
guys are
go,
going
and then
first.
you
Okay.
can
Yeah.
go first.
Yeah,
We know you're all have gone. Yeah.
okay.
Thank you.
Good. You guys go ahead. Yeah, call it. Thank you.
Go with it.
Which has it?
Maybe we'll have to change our
Like need to get balloons out.
Okay.
And so they're out there playing basketball, they're playing football, they're out there playing volleyball. Well, they're doing all these things out there. And stuff, you know?
Still our turn to hand out?
Lots and lots of.
Oh, yeah, that's right, we did.
That's how it started. Yeah.
Thank you.
Thank you.
One of these three? Eight.
Okay.
Pass it down. Here's Bernie.
Oh, yeah, yeah.
Which one are we on?
Okay,
Susie?
so Article 8, employee safety. Again, we have made a list of all the things that we wanted to fix where people were adversely affected. For example, in some of our specialized classrooms, people have gotten their glasses broken. And it said in there that we would pay $500. And Jane said that if, you know, a lot of people had lots of bells and whistles in their glasses where, you know, you go outside and it becomes sunglasses and it costs way more than $500. And so we wanted to put in there that if they could give us, that we would reimburse the full cost if they could give us the receipt. And you know what?
From the
See,
old
it
glasses.
says if the employee can provide receipt of damaged glasses above the maximum amount of 500, the district will reimburse the full cost. Because what was happening is people had these $900 glasses, but our contract said 500, and we wanted to let people know, if they could show us, you know, like if I went to the eye doctor and I got a receipt for my old ones, or even Costco or wherever I got them. So we just, that was something that had happened a couple times, and Jane felt really bad about it, so she wanted to make sure that we put that in. And then, and so that's really what we fixed in the article, other than should employee believe that state and federal regulations have not been met. We wanted to make sure that we put that in there for safety. And so we have just been making lists all year of the little things that we felt like we should change in the contract. So that was just what we changed in Article 8. Any questions on that? Yeah.
For 8.4, where you changed it from should an employee feel that a safety problem exists to have it believe the state and federal regulations not been met, is your intent that that would expand what they should report, or that it would limit from what they currently? Because like there could be safety issues that are not necessarily a violation of a state or federal regulation, but just, you know, generally seem less safe.
It was just to clarify.
Okay.
So people knew that if they believe that state and federal regulations were,
Okay, so you're trying to expand.
yes.
Okay.
And then the next one, Article 21, leave without pay, again, I'll wait till you get it, but we were just cleaning up language, because it was confusing about insurance coverage, with, protected leaves and. Thank you. And when people went on unpaid leave, we just wanted to clarify, because it was confusing to people in the article again. This was something that Elisa in the business office was dealing with a lot, and so she just wanted to make it clear that when an employee is on unpaid leave, they will continue to qualify for the district paid insurance provided they meet the minimum hour requirements specified in 26.1A. And it tells in 26.1A how insurance is done. And then, we wanted to make sure an employee on FEMLA, OFLA, or paid leave Oregon will retain insurance coverage through the end of the month in which the protected leave ends.
Question?
Yes,
Yeah, so paid leave Oregon, I believe, requires the employer to still provide the health insurance coverage.
the whole time that they're on leave.
Yeah, so, but when someone's on paid leave Oregon, they might not be meeting the hours requirements.
That's why it's separate. Because they, when you're on OFLA, FEMLA,
Yeah.
paid leave Oregon, you get to retain insurance coverage through the end of the month in which the protected leave ends.
Okay, so the second sentence is like, except this.
Yes,
Yeah, okay, because otherwise it looks like they contradict, so,
no, that's
Okay.
why we separated them.
okay.
Because we had a hard time with this and went back and forth. We just wanted, because it wasn't making sense to people before. Okay, and then, Article 34, we'll pass around, and the retire after retirement, we are putting the same thing that's exactly in the certified contract and in every conferring consult we have. So it's the same thing that's in the administrator, same thing that's in, that we just bargained with, certified, and we noticed that the classified was different, and so we just wanted to make them all the same. So anybody who worked in the district and, retired after retirement, that we would treat them all the same, no matter what, they did for the district. And so this is the exact same language from the certified contract, and we just moved it into the classified contract. Questions on that?
I have a question.
Yes.
Are they hired at sub rate or at their rate?
It tells you right there. It said classified staff retiring during the school year who complete the year continue with the same salary and benefits for the remainder of the year. No PERS payments will be made by the district. And then, for retirees hired in subsequent school years, PERS retired classified staff who are hired in any year following the retirement year shall be placed on the same salary schedule they were at when they retired. Okay?
Thank you.
Because we just wanted to make it really clear, and we wanted to make it fair, because that's exactly word for word what it says in the certified contract, and so I just moved it into the classified contract. And if you check their certified contracts online, and you can see that. So, that's what we've done, yes.
Yeah, another clarifying question.
Yes.
So, it's, I guess, 1, 2, 3, 4, fifth, the second to last bullet point.
Yes,
It says classified staff hired post-retirement will continue to earn 1 sick leave day per month.
yes.
So if this is pulled from certified, like, they all have just like a work day, right? Because they're salaried, and it's
They
like,
get-
it's averaged out, but classified have hourly,
They get-
and they have different amounts of hourly, different FTEs. So is it 1 8-hour day, 1 10-hour day,
Yeah.
1 12-hour day?
That's a good point.
Yeah, that's a really,
That's according to the
Okay.
calendar.
yeah, I should,
Okay.
it's according to their calendar. Thank you for
Okay.
pointing that out.
Okay,
If they're 8 hours, 6 hours, it's different. So thank you, Amber.
Are we going to reissue that then with
Yeah.
that change?
We'll fix that.
Okay. We'll come back to you then.
okay, thank you.
match their calendars, it's different per calendar that you're on. Yeah, they're good catch, thank you.
Okay.
Any other questions? Now, are you guys gonna move on with the rest of yours?
Yes, so we have Article 10, personnel records.
We need a pause for note.
Last reading, at least I'm hoping I did. What'd you read?
Green eggs and ham twice, Cat in the Hat, A Mouse and a Cookie.
Okay.
And then there was a really tough Dr. Seuss one, like one sock, two sock.
Oh, yeah?
Yeah, that one was tough. Yeah.
Yeah.
It was off, you've been practicing the other books and then.
No, I don't have grandkids, so this is like a hot read.
Oh, I'm sorry.
Thank you. Yeah, that was a good one.
Thank you.
Pete the Cat's always a fun one, 'cause those are.
Forgot which ones I said.
Which one?
Pete the Cat.
Yeah.
Oh, thank you.
I just did this.
Yes.
Second man, she's nice.
Just get it. There you go. She got her computer. You're not separating. The changes that we've made in this article in 10.1, just requiring that the association is also provided any information that reflects critically on an employee, so that we can best support that employee. 10.2, the removal of materials. The current language says that that any letters of caution, et cetera, can be may be removed 3 calendar years after being placed in the file. We believe that 2 years would be a fair time period for that. If we have an employee that has fixed what they have been asked to fix and goes 2 years without further incident, then that should be removed from their file.
Can I ask you a question about that? Because it says when a letter of expectation, letter of reprimand, because letter of expectation they're in a working file, and letter of reprimand are in their file in the district. And so, 2 years for the letter purged from both the working file and the file here.
So I think that Article 10.5 addresses the working file. So that's is a little separate down there. But in this intention was for both.
Yeah, 10.2 never listed like what file it's talking about. So wherever it might exist, the current contract language, wherever it might exist, it has to be removed after the 3 years. That's current language. And so then we're just saying it would be 2 years wherever it might exist.
Yeah, including, it's all personnel records.
Okay.
Okay. And then our 10.3, just making sure that anything placed in the record without following those steps will not be used for any subsequent evaluation or disciplinary proceeding. 10.4 was just some cleanup of language, some typos that were fixed. And then 10.5, making sure that any issue is brought to the employee's attention promptly, and that any action is documented. We want to make sure that we have that record. And that is it for that. Any questions on that?
I still think that it says placed in the employee's file. And letters of expectation aren't placed in the employee's file. I just think it's confusing.
So, in general, although it's not strictly stated here, a letter of expectation falls under 10.5. Is that correct? Because that's not dissimilar to a memorandum that you've had a meeting to discuss, and there's a written notice. What you guys are saying is that there's got to be written notice? Is that true?
Yes.
Okay. And expectation letters would not go to the district? Go ahead, Amber.
So under 10.2, where we've included letter expectation, letter reprimand, we've been experiencing supervisors treating a letter of expectation as targeted and specific and disciplinary. Even though I know you all think of it differently, we've had managers using letters of expectation as discipline. And so, again, if it's in that file, then we need to be able to remove it at 2 years. Whether it should have gone in there to begin with or not, we want the right that it would come out at 2 years. Because we do have confusion among managers of what they label the letters that they issue.
Because I just want everyone to know that a letter of expectation is what you expect from everyone, and it is not this one.
Yeah, but those are not issued to everyone. So it isn't expected of everyone, it's being expected of just that person that you're giving it to. Now, if you issue expectations to a whole department, that's different.
You can't just tell someone, hey, we're talking to you, here it is in writing, and it's a letter of expectation.
Yeah, you can do that.
Okay.
Yeah.
Thank you.
One follow-up question on 10.5. What's your sense of what promptly means to you? Shall be brought to the employee's attention promptly? You know, I always get a little nervous when we have terms that are sort of reasonable people could differ on what, you know, is that the next day? Is it the next week? Is it the next hour? And so I guess I'm interested in your sense, when you guys write this, what do you think of as promptly?
Yeah, we can clarify that. The intention is that it's not something that can be, years ago or
Sure.
months ago and
Yeah.
come back, but we can clarify that.
Yeah, definitely appreciate that notion that you're going to address it at the time instead of waiting, just, this, someday it'll come up. Like,
Right.
was that promptly or was it not promptly?
Thank you.
Yeah, thanks.
Any
you, guys.
other questions? Okay,
Appreciate it.
I think we have Article 12, complaint procedure.
I'm gonna trip and fall, is what's gonna take my glasses off for this. Get through this thing.
Thank you.
Just get almost all of them. Right, smarter, not harder. Right, it's fair.
I'll let her get.
All right, does everybody around the table have a copy? Awesome. So this is Article 12, complaint procedure. There's just a few small items that we felt like were important to clean up and clarify our complaint procedure process. This process is, I'll just say, overall, it can be very stressful for everyone involved. And so that's why, even if these seem like small things, they could be very important to the people involved. And so this first part we just want to have the association be able to be aware when a complaint has been processed. Again, that helps us best support our members. Sometimes if we're brought in really late, we're not able to provide, good support to help make sure the process goes well. Second, we want to replace this phrase deemed desirable to notify the employee with like, if the complaint is found to have merit. I guess it's, again, having unclear words like deemed desirable to notify, like who has a desire? I don't know who doesn't or doesn't desire. So if it has merit,
Found to have merit.
yeah. And we feel like that would be one where the supervisor should then discuss the complaint with the employee and share all the information. The part about except which the complainant has asked to be kept in confidence, the struggle with that is that if you don't share with somebody what the issue is, then they're not able to respond back to it. And under just cause law, like if you don't give a person the chance to respond to it, you can't use it for just cause. So an arbitrator will throw it out if you didn't give the person an opportunity to respond to it. And so I think like for some of our members or other people in the community, they might think I can, give this complaint and I can say, please keep me anonymous, keep all the details anonymous, don't identify anything. And then if an employee is told, hey, you're just kind of rude, you're not going to be able to discipline them because you haven't told them when, where, how, right? They've got to have details so that the person has a fair chance to give their side of it. Otherwise, the just cause won't stick. You will not be able to discipline them. An arbitrator would turn that over. So we feel like it's important that the person is able to hear what the full complaint is against them. And then under letter C, again, if the complaint is not found to have merit, not only should you not use it then in some kind of negative action against the person, you should also destroy the complaint, right? If you find that the complaint is frivolous, it does not have merit, it shouldn't like linger around and then have somebody look at it, read it, and then say, oh, it didn't have merit, so I guess we won't use it against the employee. It's like, well, why did you keep it? So we think it should be destroyed at that point. And then for letter E, that's where it said like the supervisor employee may agree to destroy it if it had no merit. What if the supervisor doesn't agree and then they're keeping a complaint that has no merit? So we felt like E shouldn't be there. And then on the next page or the back, this is the complaints by employees. There's just deleting this like for reference only. Like if the policy's in Appendix A, it's not just for a reference. We would like to follow Appendix A and be able to grieve if Appendix A is not being followed. It shouldn't be only a reference. So that's our proposed changes on Article 12. Questions?
Go ahead. Go ahead.
On that C, I mean, it's the concept is in the current language too, will be destroyed. Like, what does that literally mean?
So if it's a paper copy, then you're gonna put that in the trash or maybe shred. If it's an electronic copy, then the electronic files need to be deleted.
Yeah, okay. Yeah, I mean, this isn't so much a question, I guess. One of the reasons we would keep it is sometimes we have to prove that we investigated something, even if the complaint was found to not be deemed to be meritorious, because the district might get sued years later. There might be a claim that, hey, I reported this to the district and they never did anything. They never investigated it. They never did anything. And our liability carriers want us to be able to say, no, actually, we did investigate this and found it was unsubstantiated, and here's kind of proof that we investigated this. So that's why it sometimes makes sense to retain things like that, even when they're not found to have merit. Yeah, sorry, go ahead.
Yeah, for those kinds of retention, I mean, wouldn't you have like confidential files somewhere?
Yeah.
It wouldn't just be sitting out in any manager's desk or?
Completely. That's why I was asking what it meant to you to destroy it, because we might retain it in some way, shape, or form in a confidential investigation file.
Okay.
Solely for the purpose of proving we investigated it later. Or if the archivist rules make us, I don't memorize, those archivist rules are crazy and long.
Okay.
So that might be another reason.
So I think the current contract language doesn't really capture what you're describing. So, like definitely write up a counter proposal so that we could look at to
Great.
see what we would think of that.
Great. And then the only thing I was going to mention up in A, I do appreciate the change away from if it is deemed desirable. That's weird language, I agree. I think we're still searching for something there, though, because at that point in time, the supervisor won't necessarily know whether the complaint has merit, right? Because they haven't investigated yet. So I don't know if the complaint is valid or accurate. So I don't know if the complaint could result in discipline or a negative evaluation. This will be followed or something. I do like going away from the deemed desirable, but just maybe want to do some collective thinking about how best to frame that now.
Yeah, we can definitely think about that,
Okay.
talk about that.
Thanks.
No, I was just looking at GBM and seeing how it relates to KL, which is our broad complaint policy.
Okay, any other questions on Article 12? Okay, and we have Article 24, miscellaneous benefits.
So it's AR, okay, which is what's over
Uh-huh.
I can't lick my hands. Spreading germs.
Take two. All my car disputes related to the provisions.
Sure.
Weekends ago.
Thank you.
Says 3 PM on it.
Yeah.
Yeah,
That's weird.
love that.
Poor choice.
I
know, right?
Yeah.
We're off the clock. Oh my gosh. No, I'm sorry. Oh, you're,
Thank you.
beat that one.
2 times ago, last time? Last time?
Did you guys read our Article 24 that we
Yes.
gave you? Is this back to us?
So again, this is our opening proposal of Article 24. We had worked on it quite a bit when we before we'd received yours, but we did go back and review after receiving yours, and there has been, we made some adjustments to reflect that.
That's all.
Yes. But this is our opening proposal on this article. Okay, I think everyone at the table has their copy. Our first change was at 24.3. Basically, we just struck out the health club because it's addressed in the one right below it. So it was kind of doubly addressed. So we moved that down. And then it just kept just again, clarifying language that the district pays for CDL drivers to obtain or renew their CDL license. The fitness membership, 24.4, we believe that would be a benefit to all our members, not just those that drive our buses. So we asked that benefit be extended to all of our members. And then kept most of the language there. Just to, again, tried to just clarify that language about the payroll deduction. 24.5, the only change was a little word change there that we thought made more sense. 24.6, the way that it was described with the mileage was very confusing. So we struck out all that confusing rate and language and just kept it at the current IRS rate for simplification. 24.7, we just struck out the employees in the bargaining unit. We just said we'll pay classified employees for required scheduled staff meetings outside of the regular workday. 24.8 was the uniforms. So anything, we just added the required that the district will purchase and maintain any required. We did see that yours also said retain. We just kind of thought that the retaining the safety equipment made sense, but not reusing boots and clothing, maybe. So that's where that change came in. We agreed with the 24.9, the outdated, we had asked before about that, who was accessing that, and the response was no one even knew really about it, and that hadn't been accessed, so we agreed to strike that portion out, but also agreeing to keep the breaks as they were set out. 24.10, this was actually language that we had changed in our last contract, that the district would pay for the requiring fingerprinting and or criminal records check. So your version kind of took that out. What we did is kept it in there, but also just struck out the stuff underneath that talks about how to be reimbursed. Because if the district is paying for it, then the employee doesn't need to be reimbursed for it. 24.11, the criminal history recheck. So this article, what we were really considering in this part of it was we have a number of classified employees who have students in the district. And we've run into that problem where they have their background criminal check history and then have to again go do another check to be a volunteer in their school. So we tried to align those requirements and make it into one. And let's see, and then the 24.12 about the transportation department manual, we just felt that the miscellaneous benefits section was not the right spot for that, so we moved that to Article 6. And then finally, 24.12, again, the nutrition services employees, we just changed that language from employees who hold a position in a food service job classification. The $1 meal, if it falls within their shift, that wasn't, we had feedback that that was a benefit that was being used, and we didn't want to take that away. We did add in that excess food at the end of each meal that cannot be saved for future meals shall be provided at no cost to the employees, rather than going in the garbage can.
I thought I heard Dave say at the last bargaining meeting that they were gonna take out the dollar charge. Am I wrong?
Yes, Melissa, that's in their proposal. This is.
Oh, so I was like
This is
going,
ours.
okay, wait a minute, I'm
Yep.
so confused. Okay, never mind. Scratch, I said that.
Can I ask a clarifier?
Yeah.
You say in here to all classified employees. Does that mean all or just food service staff?
It was to all in the building, rather than going in the garbage. Yeah.
So we were told at one point that because staff can control the portioning, that it becomes difficult to understand when it's a reasonable portion of lunch ordered,
Right.
and that we're not all of a sudden serving a bunch of food that could end up being extra. It's a challenging point, right?
It would be a challenging point, and we would expect that people would still be ordering the appropriate amount to feed the students. We wouldn't expect that we would be changing that.
Yeah, I think also this came from the fact that we've had just an enormous amount of food waste. And it's just hard for folks to, I mean, it's hard on our custodial staff to literally even lift the garbage bags because the food is, so much is being wasted. And that's not because our staff are cooking the wrong amounts, right? There's a plan. The plan is being thoughtful. They're trying their best to do right by all the schools and cook the right amount of food. But when there is waste that's being thrown away, it's just hard to think that not only are you going to overwork people lifting really heavy trash bags, but then also, we've got staff who have food insecurities in their families and homes because they're not paid enough. So if you've got staff who work so few hours and earn such low wages, they're on food stamps, they're going to food pantries, and then they have to lift enormous heavy bags of food into the trash, that just seems really kind of terrible. And so we thought if there's extra, like, why not share it with the classified staff in that building? And that management does have the ability to manage how much food you are having prepared in these buildings. That is part of your discretion.
Also, I just wanted to clarify, we don't make employees, we run background checks every 5 years on all employees. We don't make employees who volunteer in their own student's classroom fill out a criminal background check.
So I think that's the 3-year, right? It's a 3-year cycle rather than 5-year. So then it sometimes gets interrupted in that 3-year cycle.
And now we're running them every year
Yeah,
for
Okay.
our classified.
So that's already being
yeah.
done.
Every 5 years.
We've, so,
Every 5.
Every 5.
yeah, to clarify, we've had members who've said, I had to pay for one because I'm not up for my 5-year yet, and I have to do it every 3 years as a parent. And it's a benefit to the district to have classified who are willing to volunteer in these schools as parents. So if you just do your background checks every 3 years, then it kind of aligns, it's all one system.
I just want you to know,
Yeah.
we have never had our employees have to pay for a background check and do another background check. If they work in our district, they're background checked.
Do we
That's
even make parents pay?
Not the reports that we've gotten. We've gotten reports of people having to pay themselves.
If that happens,
Double check that.
because to
Yep.
our
Your background
knowledge,
check
that's never
online?
happened. So if that's happening,
Oh,
we don't think so.
No, if you fill out the volunteer background check online, I don't think.
And again, it wouldn't come through HR because it's not an employment background check. It's them being told at the school they're volunteering at as a parent.
Come through HR.
They all come.
Background check?
Yes, we do
Okay.
all the.
We do them all.
I have a clarifying question on the food. Joanne, when we've talked about this issue and the heavy garbage bags before, correct me if I'm wrong, if what you have shared with us is the majority of that weight is coming from kids. I believe what you said, kids not eating their food and that food being dumped in the garbage. And then those garbage bags are heavy, not necessarily the food being dumped from the kitchen that was not served.
But I don't dump the kitchen trash, so I couldn't speak to the
Okay.
kitchen trash.
I just wanna make sure, all of
There's-
our
there's both.
conversations, right, that we've had, we're talking about the,
there is a lot.
the student dumping, okay.
And there's nothing we can really do about that. Yeah.
Angelica could speak to it,
There
though.
is a lot of kitchen waste. Yes, there is.
That's just something I had not heard of, just the other.
Yeah, we've had to deal with it at West Albany.
Thank you.
Thank you.
Any other questions on that one? Okay. And I think that is all we are prepared to present tonight.
I can tell you guys have done a lot of work and put a lot of thought in those things, and I appreciate that. I think we all appreciate it. And
Yes.
thank you so much for
Yeah.
doing the work.
Thank you.
What shall we do now? Shall we caucus a little bit and we can start to think about these different things? We know we are going to clarify one and bring it back. And you guys have one you're going to work on?
Yes.
Okay. Anything else?
I think we are at the stage in bargaining where there could end up being confusion over which article who's writing the next counter. And I don't want us to like duplicate.
Yeah.
So we'll definitely talk about which ones we might bring to you next, which balls are in which court.
Yeah, we'll do the same.
Yeah.
Yep.
Okay.
Great. Thank you, Amber. We're going to caucus then.